Well, hello everyone. Welcome. We're going to have a good day. Welcome to the America's Advertising Law Hearing Review webinar. Just for you to know, we have in this webinar 4 great panelists covering several jurisdictions from around the world. And tomorrow, for those of you who are interested, we're going to have a Spanish version with different panelists covering different jurisdictions in case you're interested on knowing what is going on around the world in jurisdictions different from the ones we're going to be covering today. GALA is a worldwide association that gathers advertising experts from all around the world. And that's the great thing about having this great 4 panelists here. We're going to cover the trendy issues on advertising from Canada, Brazil, Venezuela, and some countries of Latin America as well, and finally, the U.S. With that said, I want to mention how the webinar is going to develop. Each of the panelists will have 10 minutes for their presentation. We'll go through the panelists, and after that, we will open a forum for the participants to submit their questions and inquiries. For that, we have habilitated a question and answer section for you to submit your questions in a written form. So I'm going to be the one to read them out loud and have the panelists address all of your inquiries. With that said, I have the pleasure of introducing you to Kelly Harris. Kelly is the Canadian member from GALA. Kelly, the panel is all yours.
Wonderful. Thank you so much for everyone joining today. Thanks to GALA for organizing and hosting this great event. Thanks to my esteemed co-panelists, Jeff, Valdir, and Ricardo, and of course to my friend Carlos Alberto for moderating all of us as well. I am a lawyer in Canada, in Toronto, and I'm the leader of Miller Thomson's National Marketing, Advertising, and Product Compliance Group. So I regularly advise manufacturers and retailers and distributors of mostly consumer goods and services on all of their marketing and advertising needs. So I've started us off with just a quick agenda for today. We're going to cover some updates on privacy, some key federal cases in 2020, and then focus in on some deceptive online reviews, which has been a hot topic this year. So to start off with privacy, just a quick overview of privacy legislation and regulation in Canada for those who haven't encountered it before. It's an area of overlapping jurisdiction. So we've, of course, got public sector legislation, which applies to government and access to information issues. And then we have a whole private sector regime as well. We have a federal law called the Personal Information Protection and Electronic Documents Act, which we shorten to PIPEDA, which governs all federally regulated industries, as well as businesses in provinces without their own privacy laws. And then we have a few provinces that have enacted substantially similar legislation, namely BC, Alberta, and Quebec. And the legislation in those provinces would apply. There are also health and employment and sector-specific privacy laws, which we will not get into today. So that's your quick overview of privacy law. And what I wanted to talk about today was a couple of new statutes that are in the works. So as I said, there are some provinces that have enacted substantially similar legislation, and Quebec is one of them, and they're looking at updating their provincial legislation. So there's a bill that's not yet in force, so we have a bit of time and potentially some changes. It's right now in the committee stage, but it's been passed in principle, and it has raised a lot of concerns, in particular, some really strong new sanctions. And what I would say overall is that these proposals are very similar to the GDPR standard. So it's a stricter standard than PIPEDA, our federal legislation. And would, for example, impose new sanctions, so civil penalties of, $10 million or 2% of worldwide turnover, as well as some penal or criminal sanctions as well. It would establish a private right of action. And another key concern is the proposal of restricting sending personal information outside of Quebec. So even within Canada, it would apply some restrictions and requirements on organizations that wanted to move people's personal information outside of the province of Quebec. Mandatory data breach reporting is also something that's being proposed. Right now we have that in some jurisdictions, but not all. As well as the introduction of a new concept of a right to be forgotten, data portability and auto processing rules, which are very similar to what folks might be familiar with in the EU context. There are also proposed elevated consent for certain purposes, so that would be requiring people to actively consent as opposed to just putting things in a privacy policy, as well as a requirement to appoint a chief privacy officer. So there's quite a lot of, I think the takeaway here is that Quebec is looking to really pivot towards more of a GDPR, European Union style of regulating privacy. So if this passes, there's going to be a real concern if you're dealing with privacy and personal information in Canada, and particularly in Quebec. And the other province to keep an eye on from a privacy perspective is that there's an ongoing, well, it's closed, but there is an ongoing change to potentially look at Ontario privacy legislation. So right now, federal laws apply in Ontario, but a consultation just closed, which would have, if there is privacy law that's going to be passed in Ontario, it would supersede PIPEDA, except it has not yet. So we're still in the works of what this would look like. Proposals, though, have been made that are very similar to some of the PIPEDA requirements, but also those strengthened Quebec requirements that we just went through, including increased enforcement powers. So right now, our privacy regulators don't have a lot of kind of enforcement powers and sanctions to back up the principles of privacy in Canada. And you'll see again the pulling in of the right to be forgotten, portability, and opt-in for secondary uses of people's personal information. So again, kind of a raising of the bar of privacy requirements in Canada. Another privacy watch out is that our federal competition bureau has reached into enforcement in the privacy sphere. And in particular, there was this enforcement action against Facebook this year, which is a very key case. And in May, Facebook entered into a consent agreement with the Competition Bureau, which is the regulator of deceptive advertising in Canada. And they agreed to pay $9 million in an administrative monetary penalty and $500,000 in costs. And at issue here was misleading representations about how Facebook handled its users' personal information. So the deceptive representation was about its privacy practices. So for example, their privacy settings had representations that users could control who could see their personal information and access it. And the consent agreement is with respect to allegations, which Facebook denies, but it agrees to pay the administrative monetary penalty in respect of that Facebook actually shared that information with third-party developers, including people's posts, their messenger content, and sharing users' friends' personal information continued after Facebook claimed that it would end. So this is very unique in that it's an enforcement by our advertising regulator about misleading privacy representations. And it also applies to a free digital product, which is also very novel. So to turn now to some of our key cases, that being one of them, of course, I just wanted to give a quick overview, and I've sort of already spoken about it, but the Competition Bureau is our deceptive marketing practices enforcement agency. And this is our key deceptive advertising prohibitions, i.e. you cannot make a misleading representation that is false or misleading in a material respect. And of note, the Competition Bureau made a public statement that it's going to continue its enforcement throughout the pandemic, and in particular with respect to deceptive marketing practices. So it continues to be enforcing even in these crazy times. So one of their, and I'll go through some of their key cases in the deceptive marketing area. One being StubHub. They entered into a consent agreement in February, And at issue were some misleading claims with respect to their sale of entertainment and sporting tickets. So they're an online seller of these kinds of tickets. In particular, the Bureau raised a concern with fees that were only disclosed if consumers looked further, so clicking or turning on optional filters, and otherwise those additional charges were only disclosed later on during online checkout. And so they paid $1.3 million of an administrative monetary penalty, enhancing their corporate compliance policy, which is very common in these consent agreements. And what's interesting about this case is that it follows an earlier warning a few years ago, warning the marketplace with respect to misleading ticket sales practices. So it's another indication that the Bureau will tip its hand a little bit as to the kinds of cases that it's looking at in its warnings and kind of public statements. And it also follows the theme of enforcement on pricing issues that we have seen over the last several years. It's been a really hot topic of enforcement for the Bureau. So our next case, our next case here is, there we go. It's not a case, it's a public statement about COVID claims. And just a note that our Bureau did make a public statement about this and had issued compliance warnings regarding deceptive marketing claims about COVID-19. Things like I'm sure is reflected in a lot of jurisdictions about herbal remedies, bee-related products, vitamins, and other things that could prevent contracting COVID, or sanitation claims about killing it. So again, a recognition that consumers are very vulnerable to health claims, and in this particular case, public health concern with this pandemic. And interestingly, a coordinated effort with our food and drug regulator, Health Canada, which is responsible for the actual approval of these kinds of products should we ever get a vaccine that's approved or other therapeutic products. Another case here, I won't get into the details, but just an issue of weight loss claims. And again, this has been an area that the Bureau has been very interested in. More coordination with Health Canada on this. And at issue here were allegedly unsubstantiated health claims about weight loss, burning fat, and all that sort of thing. And I will just now turn to another sort of interesting case that's a little bit different, which is a case, it's not a case, it's a call to market participants with respect to Amazon and its restrictive or allegedly restrictive trade practices. And so what the Bureau has done is they've asked market participants to provide any information. Right now, there's no conclusion of wrongdoing. The Bureau did enter into a consent agreement with Amazon recently regarding some sales and price claims. And this call right now to the market is largely focused on, sort of an abusive dominance issue. But they've also flagged for the market to provide information about any efforts or strategies by Amazon that might influence consumers to purchase products it offers for sale over those offered by competing sellers. So I think that, it may speak to those kinds of representations that could be at issue from an advertising perspective as well. So now I will just turn in my last minutes to the issue of online reviews. And this is an area of interest, and in particular in our self-regulatory regime. So for those who are not aware, deceptive online reviews it's not specifically regulated in Canada. That general rule prohibiting false or misleading representation that we covered earlier. And there was a case about this from the Competition Bureau, which is the federal regulator, concerning some reviews that were left by employees on public app stores, where employees gave reviews that were, they were their actual opinions, but they didn't disclose that they were employees. And so we do have a federal consent agreement here, a $1.25 million administrative monetary penalty. But where we've seen some activity this year has been on the self-regulatory side of this issue. And I'll just quickly go through that, given I don't have a lot of time left. This is our clauses that are applicable to online reviews, so you can't make omissions. And we do have a specific testimonials and endorsement review in our self-regulatory regime, which is ad standards. And you can see here there's an interpretation guideline that essentially is reflective of the FTC's material connections disclosure requirements that you have to say if you are in fact, involved somehow with the advertiser. And what I wanted to bring to everyone's attention was a couple of cases in our self-regulatory advertising dispute procedure. This is a confidential advertiser dispute platform that is offered by Ad Standards for advertisers to challenge competitor claims. And it's a new procedure. These used to be confidential, and they've opened it up at Ad Standards as of 2019. And interestingly, many of the cases have been regarding online reviews. So I think it's a hot issue in the marketplace. And there's this case here from 2019, and then also a case that then was from 2020 that cited that 2019 case. And really at issue here was the practice of rounding up of reviews from a 4-point something to a 5-star. And some of the advertiser positions have been that it's permissible to do so if you disclaim it and you explain it or provide additional information. And the dispute panels have been very clear that the practice of rounding up 5-star reviews is misleading, and it's not really possible to depict an unqualified perfect star rating if not all ratings are perfect. So that's what I have to say about the updates from Canada, and I'm happy to take any questions in the chat or otherwise.
Thank you very much, Kelly. In fact, I already have a couple of questions as well. I forgot to mention that I'm not going to be performing a formal introduction of each of the members. Just because of being part of GALA, it means you're first in class and top of the world on that specific matter. So we won't need hours to explain the accomplishments and endless CVs of each of our members. So with that said, we'll go to the next member, Valdir from Brazil.
Hello, everybody. It's a pleasure to be here. Stacy, can you change the slide, please? My name is Valdir Rocha. I'm a partner of Veirano law firm in Brazil, head of IP, advertising, and franchising. And I'm going to cover hot topics on advertising law in Brazil. And I'm not controlling the slides, Stacy. So these hot topics are racism in advertising, privacy, and fake news, especially related to the upcoming elections for mayors and city council. So the first case I'm going to mention relates to racism. It's something that a due diligence in an acquisition would not be able to reveal, and it happened with Bombril, a local company that manufactures sanitary products. Many years ago, in the 50s, there was a company called Sabarco marketing a product called Crespinha, and Crespinha has a double meaning. It can also mean frizzy hair or very curly hair, and it's related to African Brazilian hair. And in the 50s, there was an association in the advertising campaign by that company of their product, which is a steel wool, to an African Brazilian girl's hair. Can you believe that? That was in the 50s. Many years later, Bombril acquired that portfolio, among others, and continued producing Crespinha, but I don't think they knew about the 50s campaign. So because of the anti-racist movements in the U.S. and Europe, and also in Brazil, in a smaller scale, but there was a campaign against Bombril because consumers found out the 50s campaign, and the brand is the same, the product is the same, and it's still in the market. So they started a campaign on Twitter against Bombril, and Bombril said that it had nothing to do with the 50s campaign, but because of the size of the campaign, of the anti-racist campaign, Bombril decided to recall the product and stop selling it in Brazil. Curious thing is that when we searched the trademark office's database, we saw that the trademarks were not withdrawn. The registrations actually renewed in July. So we'll have to see in the future if the product will come back to the market. The next case on racism in advertising was a trainee hiring campaign by a very large chain of retail stores, department stores called Magalu or Magazine Luiza, owned by a very famous Brazilian woman entrepreneur. And this is kind of an affirmative action. The head of that company, the chairman of the board, is very engaged in these types of actions, affirmative actions for women. And then the company decided to have to hire only black trainees. So there was a lot of fuss in the media and social media, and it backlashed because the Federal Public Defender's Office in the capital city of Brasilia filed a lawsuit against Magalu, arguing that this is racism because although Brazil has some 100 million African Brazilian population, half of the population is black, there are other minorities in Brazil, so the public defender is saying that this campaign, this hiring program is not contemplating minorities such as indigenous Brazilians, Asians, or even immigrants from other South American countries who are suffering from the pandemic and the unemployment caused by the pandemic. So there is a lot of discussions on whether this is reverse racism or not, or whether there isn't such a thing as reverse racism. But so there's this litigation going on. Magalu has not filed its defense, but it's something that companies have to bear in mind. Both cases. When you acquire a portfolio, your due diligence should cover prior advertising, if possible. And when launching a program of hiring, you have to be careful not to be accused of reverse racism. Another hot topic in Brazil is, of course, privacy. We have a new law that became in force last September, the 18th of September. Last year, the Data Protection Authority was created, but the law was not enforced, so the directors were not appointed. But with the enactment of the law, the president appointed the officers of the agency in August, and the courts may apply the law, although the penalties will only be applied as from August 2021. So the fines foreseen in the law, which are similar to the GDRP and to the Canadian law as mentioned by Kelly Herrick, the courts can apply. And that leads us to the next slide and the leading case involving the LGPD, which is the Brazilian privacy law, was a lawsuit filed by an individual called Fabrício Vilela against a construction company called Cirela. Cirela is a large contractor and construction company, and that individual bought an apartment in São Paulo, and a couple of days after signing the contract, he started receiving calls from financial institutions offering him loans to pay his mortgage, and from furniture stores offering sofas and curtains and lamps. And so he got so many calls and messages and emails that he was very upset, disturbed. So he sued Cirela for moral damages. And the decision was rendered very quickly and based on the new law. And the judge awarded damages of 10,000 reais to the plaintiff. Of course, that decision is appellable, and we'll follow it in the months to come. And the third hot topic is fake news and the probable regulation of fake news. There's a bill in the Senate, and it's being discussed by the society, and all the discussion involving fake news, and especially related to the elections. We had bots divulging fake news in the 2018 elections, as other countries had. And as I said, next month we're going to have elections for city governments and city councils, and the platforms will have to take care of that. So Google, in the second trimester, removed 600,000 pages and 16,000 domains from the Brazilian internet. But the reason was not necessarily fake news. Google said these messages had sexual dangers or derogatory content. And today on the newspapers, there is a note on WhatsApp takedown. In September of this year, last month, WhatsApp Brazil is the second market after India for WhatsApp. WhatsApp shut down 100,000 accounts, mostly because of fake news in Brazil only. The Superior Electoral Court started a program for fact-checking. It's called Fact or Rumor. And it brings us to a concrete case involving fake news and elections. In 2018, the gentleman on the left, son of the president, was elected as a representative of the state of São Paulo. He had 1.8 million votes, and the woman next to him, they belong to the same party, she got 1 million votes, Joyce Hasselman. And then she became the government's leader in the House, appointed by President Bolsonaro. But then after a few months, she started to support another leader who was not voting, was not leading the basis of the government, the parliament, the representatives that supported the government in some votes for bills. She was supporting an individual who was a persona non grata for the Bolsonaro family, so she became a persona non grata. And then the president's son, shown in this picture, he started a hate campaign against her, and she was overweight at the time. And he called her Peppa Pig and Miss Piggy. And so he started a campaign on Twitter to his supporters saying, stop following Peppa Pig and stop following Miss Piggy. So the president appointed another leader. She lost her position, and she started to complain about the president's son, saying that they created a cabinet of hate in the presidential palace. So this year, she's running for mayor in the city of São Paulo, and she used, instead of complaining about the nickname, she used Peppa Pig in a video for her campaign. Actually, she used the whole Muppet Show, and we're going to show the video. We can show the video now so you understand. So she used she launched that video on social media without any consent from Walt Disney Corporation. So Disney sent them a cease and desist letter. Disney sent her a cease and desist letter, and she had to pull off the video in her campaign. Next. So this is my last slide. Another case of electoral advertising by a national TV chain, TV network called Record. Record is owned by the Universal Church, an evangelical church that started in Brazil. The head of the church is Bishop Macedo, who happens to be the uncle of Rio's current mayor, shown on the right-hand side, Mr. Crivella. Mr. Crivella was also a bishop of the church before running for Senate, and now he's the mayor. He's running for re-election. So the TV station launched a campaign just to announce its new phone number, ending with 1010, 1010. And 10, coincidentally, is the number of Mayor Crivella on the ballot and the number of his party. So the Record TV used two politicians to announce its new phone number. So the Electoral Court of Rio de Janeiro ordered the interruption of the ad by Record TV, and it's no longer being shown. So these were the hot topics from Brazil. I will be glad to answer any questions if you have any. Thank you very much.
Thank you very much, Valdir. We'll go to our next panelist, Ricardo Alberto Antequera from Venezuela.
Thank you very much, Carlos, and thank you to all my friends and colleagues from Gala to give me a hand putting together content of interest to our audience today. Instead of focusing in one country in particular, what we decided was to put together a short review for all the audience, for all of you who have been kind enough to join us today, to introduce you about what's happening in the countries where new regulations are being under discussion or has been approved during the last few months. Beginning from this statement, if we believe that this is true, that the influencer marketing appears to be the hot topic of the biggest issue, or the biggest matter of interest for the advertising industry, then let's start reviewing what's been happening in the region recently. In terms of Instagram influencers, these numbers might not be completely accurate, but it gives you an idea of how big the topic has become in the region. Starting always with Brazil, which already we just hear from Valdir, an excellent presentation about recent developments in the area. But yes, Brazil is the leading country in terms of the numbers of influencers around. But the fact that Argentina is number 2, for instance, bring us to the situation where this is the first country. Argentina is the first country which is formally addressing by means of a new law that has been introduced to the Congress just at the end of June, and is under discussion now by 2 commissions of the Congress, ruling on influencers. So it appears that, as we will see later on, the region is slowly moving to formal regulation on the issue, which is a matter that will be, I'm sure, discussed on a regional basis, because as we have learned in the past, whenever the private sector do not take the initiative to implement self-regulation rules, then it leaves to the legislative the possibility of ruling on the matter, and in the majority of the cases, the outcome is not positive, or at least is conflicting. So which activities are covered in this bill? Once again, it's just a bill. All unboxing contests, sweepstakes, pictures, video, or any other ad or promotion made or to be made through social media is ruled by this project. The requirement goes obviously to labeling, as we always know. Labeling is a critical issue. In this case, it is mandatory it would be mandatory publicidad paga, a full disclosure about who the advertiser is, who developing the sponsorship relationship between the influencer and the brand must be also disclosed. Especially if there's sensitivity when it comes to if the advertising is addressed to children or teenagers. And the discussion is the influencer, the individual, must be registered before the Argentinian tax agency, tax authority, in order to receive payment for this commercial initiative. As to the draft in terms of sanctions, is proposing fines within 10 and 1,000 minimum wage salary. So let's see what happens with that legislative initiative. But the response to that is something that we've been learning in Latin America. the self-regulatory body, the Argentinian self-regulatory body, came up with an answer, taking the initiative as a response to the bill, publishing a best practice guide, a guide to communication for commercial purposes, inviting people to use the hashtag ADAD or hashtag partnership, which in Spanish means publicidad paga or contenido patrocinado, in all advertising where influencers are involved. So it's this once again is something that we're learning from experience. It's better to take initiative instead of waiting for the government to take action. Also from Argentina, this is just really coming right from the oven. It's going to be enforced in December 2020. It's perhaps a new response from the new reality where there has been an explosion, a growth in the field of e-commerce on a lot of jurisdictions, including those who were a little bit behind, like Venezuela. It has exploded certainly in an important way, and perhaps as a response of that growth, the numbers of customers now being heavily involved in e-commerce transactions, especially because obviously of the pandemic and the reality where a lot of Latin American countries remain in partial or even full lockdown, depending on the moment. Then a cancellation button for certain transactions is going to be mandatory for those industries or commercial actors involved on e-commerce. This cancellation button will have a few exceptions. First, for tailor-made products, obviously. Then, depending on the nature of characteristic of the product, when it does not allow it to be returned. An interesting clarification for the entertainment industry. In the case of sounds or video recordings, these are computer programs that can be downloaded or reproduced immediately for permanent use, and then newspapers, periodicals, and magazines. The new regulation established that within the next 24 hours after the consumer has requested the withdrawal, supplier must provide then a code number to start the process. In the case of Colombia, we have two important topics to comment on. Obviously, as in everywhere in the world, there have been cases related with COVID, people trying to take advantage of the situation, of a negative situation. In this case, a well-known model, Elizabeth Loaiza, uploaded the video informing or announcing about a test for COVID, which theoretically was already approved, number one, by Colombian sanitary agencies, and number two, was supposedly to be exclusively sold by the governmental circle, by public authorities. Ex officio, a procedure was started after the health authorities found out about this false advertising, and the Colombian Consumer Protection Agency started a procedure against this individual, finding out that the test was by the Colombian health authority, and that, as in the case of a medical test, advertising cannot be entitled, cannot be allowed. So the initiative was taken down, and now the individual is facing a fine of approximately $500,000. So that shows that even in absence of a specific regulation, as it happens in the majority of the countries in Latin America, consumer protection rules remain fully enforceable against this irregular situation. Just also, hold on. Before getting into the Mexico situation, I just want to comment that at the beginning of this month, a best practice for influencer, a best practice code was approved by the Colombian Consumer Protection Agency. Mandatory is an invitation to behave in certain ways, to disclose that there are a commercial relationship is ongoing. So it's not a set of rules for mandatory applicable, but it's an invitation to comply with. So let's wait and see what the future is in terms of compliance with this set of new rulings from the Consumer Protection Agency in Colombia. And finally, just leaving from the marketing influencer topic, in terms of labeling and brand restrictions, we have a very important development that I'm sure will be part of the agenda for the advertising industry for the next few months. It's already on the conversation, but it's gonna. My guess is gonna get even more tense. It's gonna be in the agenda of everybody in the advertising industry, because it will be enforced from April of next year, and it basically contains two heavy new set of rules. Number one, ruling on the information that has to be on the front of packaging for certain food and beverage and non-alcoholic beverage, informing the content of critical nutrients and ingredients in the event of excessive consumption. I'll show you an example of how a product would look like. And the other one, which is not, I wouldn't say that it's not the first country in Latin America that rules on this, but being Mexico such a huge jurisdiction, such a big market, not only for global brands, but where really important local brand is going to be tense, the situation, I guess, is banning from use in certain products where which could represent risk for health of children in the case of the excess of critical nutrients or sweeteners. There's a full banning, completely forbidden to use animated cartoons, celebrities, athletes, text, any interactive elements that can be considered there is inciting, promoting, or encourage consumption to the children. So this is just to finish up an example of how a box of cereal will theoretically look to these regulations comes into force next month. To the left, you see in the left-hand side of your screens, you can see how the current presentation is, and to the right-hand side, how it would look like. So with that, I'm open to answer any questions you may have at the end of the presentation, and thank you very much for your time.
Thank you very much, Ricardo, for your overview on some of the countries in Latin America. Last but not least, we have Jeff Greenbaum, a member from the U.S., and actually the president of GALA. Jeff, the panel is yours.
All right, Carlos Alberto, thank you so much. You know, it's so jarring to see myself in a suit standing in my office. Both of those things seem so completely far away at this point. But at least it's not a photo that shows me with hair. So anyway, let's jump in and talk about the U.S. In terms of some of the hot topics that are going on in the U.S. right now, influencers continues to be still one of the big ones. We continue to see a lot of enforcement, particularly by the U.S. federal regulator, the Federal Trade Commission. The main focus of the FTC's efforts has really been ensuring that influencers that have a material connection with a brand that is not reasonably expected by the audience is clearly and conspicuously disclosed. I would say the key issue at this moment is probably how unavoidable that disclosure is. You know, at the beginning, there was a real focus on getting the disclosure. Then we started to talk about what the right language is for the disclosure. And now finally, we're at the, okay, are you going to actually see it? And the key thing right now is ensuring that if you do have a disclosure for an influencer, that it's available before the fold. The idea that you don't need to click more, that you don't need to expand a box, that you don't need to go anywhere else or do anything to see that disclosure, but ensuring it's something you see when you see even just the smallest or most condensed part of the post. Another interesting issue that has come up over the last year or so has been enforcement at two companies who have been selling fake indicators of social influence, the idea of boosting your followers or boosting your likes in a fake way. And the regulators have indicated that they believe that that's a deceptive practice as well. And then finally, consumer reviews are an issue in the U.S. as well. The concern with either fake consumer reviews or incentivized consumer reviews not adequately disclosing how they were incentivized to post them. Another interesting sort of twist on that is also not only the fake reviews, but ways in which companies can alter the way reviews appear on screen to sort of lessen the impact of negative reviews, and whether that could be a deceptive practice as well. The thing to keep an eye on right now is the FTC is engaged in its once every 10 years review of its endorsement guides, which is sort of the primary guidance, the source of the primary guidance for the use of influencers in the U.S. The guides get reviewed as a regular matter every 10 years, though for social media, it's pretty significant because many of the social media platforms that we're on every day, including Instagram, weren't around 10 years from now. So I think that we expect that when we look at this endorsement guide review, we're going to see some fairly significant guidance that really hones in on some of the practices that people are struggling with today. When you look at the kinds of questions that the FTC is asking, one of the things it shows is they really know what they're talking about. They've really thought about the issues. They understand the challenges that advertisers and influencers are having, and are really willing to ask hard questions about, even is the advice that they've been giving correct? So they're asking, do the standards that they've set forth, do those standards really work? And are there situations where disclosures are not really necessary? So lots of really interesting questions going on here. Another sort of continuing theme that you'll see through this presentation or through FTC enforcement generally is the FTC asking whether its general advertising enforcement program is working, whether it's been strict enough, whether when they seek remedies, they're seeking severe enough remedies, and whether in their settlements with advertisers, they're seeking significant enough damages. One of the questions in the endorsement guides is the endorsement guides are just simply the FTC's view about what would be deceptive under Section 5 of the FTC Act. It's not actually independently enforceable as a rule or regulation. But one of the questions being asked is that still sufficient? Or in today's world, do we actually need a rule that can be independently enforced by the FTC, which has civil penalties attached to it? Speaking of another question of whether we need civil penalties attached to it, another area that continues to be one of the FTC's main areas of enforcement focus is made in the USA claims. This is when you claim that your product was made in the United States. FTC probably brings 20 or so cases about made in USA every year, probably more than in any other area, except potentially maybe sort of hardcore health product fraud cases. In order to make a claim that a product is made in the United States, you need to substantiate that the product was all or virtually all made in the United States. The FTC has not provided specific guidance, though, about what does all or virtually all mean in terms of a specific percentage or cutoff. There's nothing out there that says 85% counts or 95% counts or anything like that. Instead, you have to really look at sort of all the facts and circumstances surrounding the product. Are the raw materials really far removed from the final product so that consumers wouldn't expect you to count the raw materials when you're thinking about your made in USA analysis? Another really important part of the analysis is asking if there are any minimal foreign inputs into the product, whether the cost of those foreign inputs when compared to the overall cost of producing the product is significant or material in any way. So interestingly, like the endorsement guides, the FTC is also exploring whether to change the way it's enforcing its Made in USA standard. There is sort of a very public debate happening among FTC commissioners about Made in USA and other issues about the question of the effectiveness of enforcement. And as a result, one of the things that's come out of that is the FTC has proposed a new Made in USA rule. And the significance, as I said before, is that it gives the FTC the ability to directly enforce the rule as opposed to just enforcing Section 5's prohibition on unfair, deceptive acts or practices, but it also gives the FTC the ability to seek civil penalties, which are almost $50,000 a violation, which it does not have under its normal false advertising authority. Here's an example of a Made in USA case that the FTC brought over the last year. This is a case involving sort of adhesives, and this is actually, well, it wasn't actually FTC, it was brought to the FTC by the NAD. Basically, the question in this case was, when you make a Made in USA claim about this product, does it include the packaging of the tube itself, or does it just include the stuff in the tube? NAD, which is our self-regulatory system, had said that the Made in USA claim applies to the product and the packaging, but the FTC said that so long as the packaging itself isn't something that's material to the way that the product is used or something that you would retain after the fact, that they understand a Made in USA claim to just apply to what's in the tube itself. Okay. so in the category of something that's already a rule and something that can already subject advertisers to substantial penalties, it's the mail order rule. The mail order rule is not often enforced by the Federal Trade Commission, maybe a couple cases over the last 10 or 15 years. However, in the last year, as you might expect, the FTC has taken a bigger interest in the mail order rule, and we've certainly seen more mail order rule cases in the last 6 months than we've seen in the last bunch of years. What's the mail order rule? The mail order rule applies to any products that are purchased by mail, phone, or online, and that's, of course, what makes it significant today. And there are really two key requirements to the mail order rule. The first is if you make a shipment representation, in other words, when you're going to send or deliver a product, you have to have a reasonable basis for that claim. If you tell people you're going to ship next day or you're going to deliver next day, you'd better make sure that, in fact, that's something you're going to be able to do. But this is the hard part. The hard part is that if you make a shipping or delivery representation, and then it turns out because of unexpected demand, because of weather problems, because of whatever, that you're not going to be able to do what you've promised, you have to give consumers notice within that stated time period that you're not going to be able to do it. And then based on when you will be able to perform, you have to follow certain procedures to give consumers notice and an opportunity to cancel, as well as a prompt refund. For massive e-commerce operations, having a mail order rule compliance program in place doesn't happen overnight. It's not uncomplicated, but if you are shipping things by mail, as pretty much everyone is today, it's important to make sure that, in fact, you have a process in place to do it. The problem is, again, because it's a rule and because the violations are substantial, if you end up having thousands and thousands of products that, either you made promises about that you couldn't satisfy or that were delivered late and you didn't provide proper notice, you could be facing, 7, 8 figures or more of damages from the FTC. And here's just one example. Fashion Nova website made fast shipping claims. The FTC said they weren't in compliance with the mail order rule, and they paid $9 million. So that gives you an example of the type of enforcement. The FTC over many years has continued to hold advertisers to a very, very high standard of substantiation. The substantiation standard in the U.S. is simply that if you make an express or implied claim in advertising, you must have a reasonable basis for those claims. The types of substantiation that you need to have are going to depend on the types of claim that you make and the likelihood that consumers are going to be able to figure out themselves, the harm that they will cause if the claim is not what you said it is. But one of the things we've seen over time with the FTC is the FTC is wanting to make sure that, number one, that there is a very, very close fit between the substantiation that you have in the claims that you're making, but then in many cases that you have competent and reliable scientific evidence to back up the claims that you make. Here's just one example. This is a case the FTC brought in last year over brake pads. A company was claiming that making claims about the performance of its brake pads, the comparative performance. They had a study actually to back up the claims that they were making, but the FTC didn't agree that the study was being properly conducted. So sort of gone are the days where you can do kind of a simple, informal study in-house and not worry about following, strict scientific procedures. If you're going to make claims that require substantiation, you're going to have really good proof to back it up. And last, it's hard to talk today without talking about the election, but other than the election, it's hard to talk about without talking about COVID. We have seen at the FTC, at the state level, at the self-regulatory level, a really, truly unprecedented level of enforcement, both through warning letters, self-regulatory enforcement, lawsuits. I would say that the core focus of that has been unsubstantiated health claims, whether it's vitamin C that's going to cure COVID, or whether it's a fan that's going to make COVID go away, price gouging, lots of concern, lots of lawsuits around the country about companies and distributors violating state laws that prohibit excessive price increases. And then finally, we've seen a number of cases where advertisers are sort of luring people into the store by promising some level of government relief. I think a particularly egregious example is the FTC sued an advertising agency for sending out a mailer basically saying, here's where you get your COVID relief check. And then when people got there, it was just a used car sale. So I would say the COVID-19 enforcement continues. I think that the regulators, both at the federal, state level, as well as in self-regulation, have really shown that they're able to pivot and focus on an issue that's of sort of primary importance, and we're going to continue to see a lot of attention on that. And I think with that, that's it.
Great. Thank you very much, Jeff. From what we see, we have in common several topics such as data privacy and influencers going on in the region. I'm going to start the questions which are already coming in the same order that our panelists had their interventions. So let's start with Kelly. Kelly, you mentioned that regarding data privacy, probably enforcement and sanctions should be strengthened. How do you think they should occur, considering that your question might be or should be understood as a suggestion to those jurisdictions and clients in which this topic, data privacy, is an emerging issue as well and probably not specifically regulated yet?
Absolutely. That's a great question. I think what I would say is that privacy is increasingly a global issue. So certainly, if organizations based outside of Canada are engaging with Canadians, then Canadian law will apply. But if you don't have laws or this is an emerging area, I see a real convergence of global norms, which may be persuasive outside of legislative obligations. For example, I'm seeing global companies increasingly applying a strictest standard for data management. So seeing GDPR requirements being included in Canadian contexts. And even in Canada, we're starting to be influenced by global privacy norms, as evidenced in the Ontario and Quebec proposals. So what I would say is, even if you're not specifically regulated, you may increasingly see a push to comply with global norms because data is so portable and it's such a global issue.
Thank you very much, Kelly. Valdir, regarding the racism cases that you mentioned, do you think that in the last years, the bar or the standard has increased regarding this topic, meaning that probably several years ago, you could get away with some kind of advertisings that would not run through today or could be banned, and thus having your clients to redo their internal clearance on this type of ads or products?
Well, racism has been considered a crime in Brazil for a couple of decades. So we don't see racist advertising in Brazil. We haven't seen in the last few years. What increased this year because of the demonstration following the death of the American citizen and also the demonstrations in Europe was an anti-racist movement in Brazil, which of course went to social media, spread out in social media, and but it doesn't mean that commercials were racist before this new wave of anti-racism. Okay? So what it brought was, research for old racist commercials to link to corporations that are still using the brand.
Thank you very much, Valdir. Ricardo, we have some questions for you on the questions and answers section from Alejandro Ferrara. And this, I'm going to pair them up with a question of mine as well. Influencers is a hot topic through several jurisdictions in Latin America. And we see that most of the countries do not have a specific regulation on that matter. And you mentioned the case in Colombia and Argentina. Alejandra Ferrara asks, in the specific case of Colombia, do the companies that make the tests might have any liability in these cases, even if the company had no contractual relationship with the model who made the claims or was understood as a sponsorship?
of the test was, hello?
Part of your...
I'm sorry, can you hear me now?
Yes.
Okay. So I don't have the details to know if the company was behind, but surely if there was no relationship or if the company was not aware that this individual was advertising these products, in theory, in common sense at least, there shouldn't be no responsibility at all. In fact, the case was started by the Consumer Protection Agency against the individual. I know that in general terms, a case like this, when what is expected from the influencer is a level of credibility in the same way, if there's a relationship, that the brand would have used when advertising its own products. In those cases, there will be responsibility also for the brand. But in the absence of a commercial sponsorship or a commercial contract to impulse, to move, or to take initiative to advertise this test, I don't see how the company could be held responsible. And well, the other questions you asked about the regulations on influencers, what is important is for people to understand that even if there's no specific regulation on certain topics in Latin America, there is a set of regulation ruling on consumer protection, data privacy, even in cases in countries like Venezuela where we don't have, or where a body of ruling on consumer protection has become really weak for particular reason that has nothing to do with trying to diminish the situation of the consumer, but for mistake made by the Congress. You can never forget that there's a ruling covering consumer protection right as a constitutional right. So in the event of any infringement from an influencer, in the absence of regulation, any agency or a court could take action based on the interpretation, for instance, of the Constitution. So we have to be aware of that. It doesn't. We don't need a specific legislation on influencer or on any other topic related with advertising if we go back to the Constitution or specific legislation that, like the Consumer Protection Act.
You know, maybe I just want to say one thing, which is that I think that, you know, when you're thinking about sort of when an influencer disclosure is required, and, you know, this is obviously specific to the U.S., but it's important to think about it not in the context, especially in the U.S., of control or contractual relationship, but material connection. Right? Often it's the case that you have a relationship with somebody. It could be your employee, it could be an influencer, it could be someone you've given something for free to, and you don't have there's no contractual requirement for them to post something, or you're in fact not even expecting them to post something. But if there is that kind of relationship, that's where that disclosure is required. And that's different, and that contrasts with other countries' standards. For example, in the UK would require something more like control over what the post is going to be. But from an FTC standpoint, from a US standpoint, we're much more focused on, you know, is there a relationship there? And if there's a relationship there, a disclosure is required, regardless of whether the post is required or not.
Thank you very much, Ricardo and Jeff. And going a little deeper on this, and taking one of Alejandro Ferrera's question as well, under many of the aspects that we've been talking about, and specifically here on sponsorship, and there's something that underlies beneath, and it's veracity. And even though if there are no specific rules, for example, in the Ecuadorian Constitution, you have the fact that advertising has to be truthful. There has to be truthfulness, not only on the content, but also regarding the message. Would this in your countries be understood as that if there is any kind of relationship, it should be disclosed, even there's not a specific rule that tells you to disclose that it's a paid ad, just because of the fact that the message has to be truthful in every way. Not only the product, in fact, those characteristics are truth, but part of the advertisement is that I'm talking on behalf of the specific product because I'm being paid for. Would that fall in within the truthfulness of advertising in each of your countries? Let's start with Jeff.
You know, let me answer it this way, which is that in order for something to be misleading in the U.S., let's just say under federal law, it must be materially misleading, which means that it must be something that will be important to consumers when making a purchasing decision. So it should be that there is a group of relationships, a group of incentives, a group of things that happen, a whole bunch of things that happen that wouldn't necessarily be material to a purchasing decision and therefore don't require disclosure. And I think that when the FTC first came out with its revised endorsement guides a decade ago, I think there was a strong instinct and recognition that you really have to look at each incentive that was provided and ask the question, hey, is this the kind of relationship that would really make a difference to consumers and something that they need to know? And I think at that time we were really thinking, okay, well, how valuable is the thing that they've got, and how much is that going to matter to someone, and something like that. But I think that the sort of the pendulum has completely shifted, and I think that, you know, one might argue that in the U.S. the FTC has really completely forgotten about the materiality standard and basically believes now that any kind of potential relationship, incentive, connection, brief meeting on the sidewalk somehow now requires disclosure. I mean, just take a simple example of, take some celebrity that makes $20 million a year, and the advertiser sends them a gift card for $5 to go to their local Starbucks, right? I think the FTC would say, well, they got a free gift card. If they post about it, they have to disclose it. But of course, it's ridiculous, right? No celebrity who's making $20 million a year is going to post and feel like they've got some special relationship with an advertiser because they got a $5 gift card. So I think that what the law requires in the U.S. right now is not something that necessarily our regulators are focused on, but it's going to take some lawsuits to really kind of suss that out. So bottom line is, we're approaching it very, very conservatively in the U.S. The Federal Trade Commission has basically said almost anything could be a material connection, and therefore really almost any type of relationship at this moment we're recommending some sort of disclosure.
Frank, Kelly, how about Canada?
I think a very similar analysis would apply in Canada. At issue is whether a credulous and inexperienced consumer would find the post to be misleading in a material respect. So there could be anything that could result in that sort of misleading general impression, and that's the basis of our analysis. Things like a relationship, as we saw in the Bell case, the reviews from the employees were not, at issue. It was not whether or not it was their true and honest belief, but rather that an employment relationship might change the perception of that review in the eyes of someone who is reading it. And so I think anything that could be material should be disclosed, if not otherwise clear from the context. Jeff's comments about celebrities, for example, when I'm looking at a post from somebody who is very, very famous, certainly if it's on my cereal box, I'll know that that's advertising. But even somebody who otherwise might be clearly posting commercial content, if the context is otherwise unclear, then you may need to make a further disclosure.
Valdir, will that be the case as well in Brazil?
Oh, similarly, yes. We have to remember that social media influencers are a very recent phenomenon. Before them, TV commercials and outdoors showed celebrities. And in Brazil, most of them were soap opera actors and actresses and some soccer players. So they appeared on billboards and on commercials, and everybody knew that was a paid ad. So there was nothing to disclose or to disclaim. But now with influencers on social media, some very new phenomena are appearing. Very young influencers. They have no previous history as celebrities. They became famous on social media. So the same legal principles apply to them, the same regulations, the Consumer Protection Code and the CONAR Code, the Self-Regulation Code. So it has to be truthful and cannot be misleading. And in the case of social media, it should have a disclosure or the disclaimer that it's sponsored or paid. So nothing more than that, because as I said, we don't have a special law for influencers or testimonials.
Thank you, Valdir. Ricardo, would that be the same case for Venezuela and some of the jurisdictions you've talked about, in case you've been able to verify this?
Somehow the same. In the case of Venezuela, we already had a regulation. We were one of the first countries in South America where a law ruling on advertising for media was approved by the Congress more than a decade ago. So we already had, even before the word influencer and the expression influencer marketing was started use, we already had it in our system, with the obligation to disclose that that particular message was a sponsor or was part of an advertising campaign. So with that idea in mind, obviously nowadays everything has to be disclosed. But in general, when you don't have a specific regulation, as I said before, in my opinion, whenever we're in the presence of a potentially even deceptive, misleading, abusive, or any message that eventually could impact on the decision process, that should be disclosed, certainly, for the people to understand and knowing that there's a commercial relationship ongoing. So full disclosure is advisable.
Thank you very much. And Ricardo, I'm going to shift from this matter to another one and take one of Alejandro Ferraro's question regarding the case in Mexico. Let me search for it. How valid, and I know this is a tough one because you're an IP attorney as well and a trademark right defender, as most of the ones here as well. How valid is to transfer the responsibility for good eating habits to the companies instead of the consumers?
Wow. That is a class of rights. There's certainly a conflict that goes way out of our jurisdiction for this conversation today. Certainly it's a conflict of rights. There's a freedom of choice from the one hand, the right of the obligation from the government to protect the citizens, citizens for health reasons. There's intellectual property conflict here when there are limitations or restrictions in the use of brands or copyrights, as I show in the image of the packaging for a cereal. So it's not an easy one. It's been the same during the last 30 years since the banning on tobacco started. This conversation is not this is not the first decade where we're going to have this conversation. So this is an ongoing conflict. This is an ongoing topic. It's already covering the tobacco industry. Alcohol also has restrictions, so it's nothing new here. The plain packaging we have also the experience of the plain packaging. So it's an open topic that will depend or will rely on each society, I guess. I anticipate that there's going to be a big conflict, as I said before. In spite of the question that was posted, the point is there are big interests, as they were in the tobacco industry in the past. There are big interests here in conflict. So I'm anticipating a huge clash between the interested parties.
Thank you, Ricardo. I don't know if any of the panelists would want to comment on this. Otherwise, I'll go to another of the questions. Great. Jeff, regarding the mail order rule, how can the shipping claims under this rule be enforced by international purchasers?
Well, how can it be enforced? Well, so the mail order rule is not, there's no right of action for consumers under the mail order rule. It's simply a rule that's being enforced by the Federal Trade Commission. So I think that in that situation, I mean, if there was a false shipping claim that a consumer relied on, you know, they would likely assert the claim under state law for false advertising. There isn't really under federal law a right of action for consumers to bring a false advertising claim. But under federal law, the main right of action from the mail order rule is going to be from the Federal Trade Commission itself. And the way those cases tend to come about is that the FTC gets a lot of consumer complaints, and suddenly there's a spike because some company is just not delivering. That kind of leads to an inquiry. So that's really where those cases are coming from.
Okay. Thank Alejandro Ferrara again for that question. And just trying to wrap it up and finish, Kelly and Valdir, who spoke about data privacy, what would be your one suggestion to any of your clients regarding the way of gathering and managing data from the clients, from their clients?
Kelly, go ahead.
Thank you, Valdir. I would say be very mindful of your procurement process when it comes to third parties who are going to be handling data. I think a lot of the risk comes from those sorts of relationships. And I think increasingly it makes sense to have a central procurement approach if you have a lot of third-party vendors who are handling personal information on your behalf, particularly if they're located outside of Canada.
Well, in Brazil, the law is very new, as I mentioned. It's a little over 1 month old. So because many companies didn't comply, or were not in compliance, there's this 1 year grace period before penalties will be imposed, and fines will be imposed. So right now in Brazil, I warn companies to start, the companies that haven't done it yet, to start doing their homework and to be in compliance with the law in the next 12 months. And the privacy specialists will let them know what to do with the data they already have in storage, and how to process new data, and how to storage data, and the new guidelines for employees and suppliers and clients, and do everything by the book.
Thank you very much, Kelly and Valdir. Well, I think we've taken enough of your time. It's been a great pleasure having you here and moderating this panel. I think we've addressed all the questions that we have in our Q&A section. I hope you all attendees have enjoyed swimming through the knowledge of these panelists, and I hope we have the opportunity of getting together on the future and hearing what you have to say about the advertising developments in each of your jurisdictions. With that said, again, thank you guys a lot. Have a great day. Take care.
Bye-bye. Thank you.
Bye-bye.